Our next panel is on trade secret law. Professor Manel mentioned some issues with trade secret law, and I think it's a good segue into this panel. I'm going to introduce the moderator, and then I'm going to let her introduce her panelists. Our moderator for this panel is Peggy Keene. She owns and operates the Keene Law Firm. She is a solo practitioner and provides tailored legal counsel on a wide range of intellectual property issues, ranging from brand protection, video games, mobile applications, licensing, cybersecurity, and consumer privacy. So please join me in welcoming Peggy and her panel.
Thank you, Keith. Okay, so to my left is Professor Sharon K. Sandine. She's the director of the Intellectual Property Institute and professor of law at the Mitchell-Hamlin School of Law. She's an internationally recognized expert on trade secret law, having written the first case book on trade secret law in the United States. Her expertise spans all aspects of intellectual property law, including trademarks, copyright, computer and internet law, and she is the editor of the IP desk book for the business lawyer. She's an active member of the local, state, and national bar associations and was elected as a fellow of the ABA Foundation 2012. Please help me welcome Professor Sharon K. Sandine. At the end of the table is Professor Megan J. Ryan. She is a Gerald J. Ford Research Fellow and Associate Professor of Law at the SMU Dedman School of Law. Her expertise encompasses a wide variety of different fields of law, including criminal law and procedure, torts, and law and science. Prior to entering academia, she was an IP litigator with Dorsey & Whitney, LLP. In addition to her legal background, she brings expertise and perspective from the scientific side of academia, having conducted research at the Mayo Clinic and the University of Minnesota in bio-inorganic chemistry, molecular biology, and experimental therapeutics. Professor Ryan mainly focuses her recent research on the impact of evolving science, technology, and cultural values on criminal convictions and punishment, as well as their impact on civil remedies. Please help me welcome Megan. Okay, so we're going to start with our presentation by Professor Sandine. She's going to kind of give us a background on the DTSA. How many of you guys know trade secret law, or feel like you kind of need a primer on it? Just go ahead and raise your hand. Trade secret law, get a primer on it. We're getting a lot of new things from the DTSA, as Professor Manel kind of pointed out. So Sandine is going to walk us through a little bit of a primer of the DTSA of 2016.
Thank you very much. And I want to thank the organizers for inviting me to be here. And actually, we have a double Minnesota connection here because Professor Ryan went to the University of Minnesota, another great law school in the Twin Cities. I'm really happy to be here and excited to be able to discuss the social justice aspects of trade secret law. There is a handout going around, which is the Economic Espionage Act of 1996 as amended by the Defend Trade Secret Act of 2016. And just so you know what you're looking at when you get that handout, if you just go online and print out the Defend Trade Secret Act of 2016, you get the legislation, and it says, you know, go to this section, change this word, amend this word, add this section, and so forth. And so what I did was I actually did that for you. And so you can see the old law and the new law, how things have changed. I want to begin by quoting a statement by Professor Manel in his article, Property, IP, and Social Justice. He wrote at the end, in addition to the conventional issues involved in assessing the internal validity of IP regimes, scholars must also explore the broader range of social justice concerns bearing on the particular intellectual property modality. human rights, distributive concerns, and other externalities such as environmental degradation and climate change. I agree wholeheartedly, but I would argue that trade secret law has been doing that all along because its genesis is the law of unfair competition. And it has only been since courts and scholars forgot about or perhaps ignored the unfair competition groundings of trade secret law in favor of a property rights and utilitarian vision that some trade secret cases lost their way. The truth is that the scope of trade secret law, and I should say, you know, as I was thinking about presenting, I go, darn, I don't have any props. I don't have music. I don't have other things going on. So anyway, you'll have to bear, I'll try to make this as exciting as possible without props. But the truth is that the scope of trade secret law has long been limited. It has limitations on its scope and application that were specifically designed to balance trade secret rights against other social values. And these social values, which I will get into more, include competition, information diffusion, and employee mobility. In fact, the history and context of the Uniform Trade Secrets Act, which I will refer to as the UTSA, was specifically designed to restate and reinforce these limitations. In other words, the law of trade secrecy at common law was kind of getting out of control, and it was the drafters of the UTSA's express intent to rein it in. Now, both the DTSA, the Defend Trade Secret Act, and the EU Trade Secret Directive can be interpreted as further strengthening and in some cases expanding these limitations. For instance, and I won't go into a lot about the EU Trade Secret Directive, but it begins with a preamble and early articles that specifically note the need of EU countries to follow the EU Charter of Fundamental Rights when they implement the Trade Secret Directive. And that charter, you know, we could think of it as our, you know, in the United States as our, you know, amendments to the Constitution. It's very similar, but it has a broader list of rights. Includes the freedom of expression, the disclosure to public authorities, the disclosure by public authorities, employee mobility, and the rights of labor unions. So let me begin. I'm going to go through three things quickly. Recent developments, Trade Secrets 101, and then I'll get into the social justice issues. So this was a very monumental spring and summer for trade secret scholars and trade secret owners because on May 11, 2016, President Obama signed the Defend Trade Secrets Act. And for those in the audience, it went into effect immediately on May 11. And then within a month, the EU Trade Secret Directive was approved by the European Parliament and the EU Council, and that triggered a 2-year period in which all EU countries must conform their laws to be consistent with that directive. And both laws are modeled after, but are not entirely consistent with, the UTSA, and I will go over some of that. And also, you know, for those in the audience from Texas, which I assume most of you are, you know, Texas is one of the newer states to adopt the UTSA. They adopted it in 2013. So the evolution of trade secret law went from the common law, which it was actually borrowed from England, came over to the United States, found its way in the UTSA, and now, as I like to say, is going back to Europe in the form of the DTSA and the EU Trade Secret Directive. Now, the state of play prior to the DTSA was that there was no civil cause of action for trade secret misappropriation in the United States. If you wanted to bring a trade secret claim, you had to either bring it in state court or you had to bring it in federal court under diversity jurisdiction, or append it to another federal claim, such as a claim under the Computer Fraud and Abuse Act. Now, with the DTSA, you can file a claim both in federal court and in state court. Now, there are some, in the state, at the state level, 47 of the states out of 50 have, and plus the U.S. Virgin Islands and Puerto Rico, have adopted the UTSA. There are some differences between the different laws, but I don't think they're very significant. New York and Massachusetts are the only states that have not adopted a statute. North Carolina has a statute, but it's not technically the UTSA. So let me go over the differences between the DTSA and the UTSA, because this is really the best way to understand what's going on. The core of the two bodies of law are essentially the same. The definition of the trade secret is very similar. It's not identical. I'll explain the difference in a moment. The definition of misappropriation is exactly the same, which is great. The remedies are exactly the same, but there's a new remedy in the DTSA, which is called the civil seizure provision. And the statute of limitations is exactly the same, 3 years. The differences are, because it's a federal law, which was adopted under the Commerce Clause of the Constitution, is there's a Commerce Clause provision in the DTSA that must be satisfied factually. There's a factual predicate that has to be proven. There's defenses put in the DTSA that are explicit. They are not part of the UTSA as adopted. They're in the commentary. But I noted in preparing for today's talk, they are in Texas's version of the UTSA, and that is the defenses of reverse engineering and independent development. The big difference is the civil seizure provision, which is new. It's ex parte civil seizure provision. If you meet the very stringent requirements, allows you to go into federal court, get an order ex parte, and have the U.S. Marshals seize property that is used for the dissemination of trade secrets. That may or may not include the trade secret themselves. It may include computer equipment, cell phones, that kind of thing. As Professor Manel mentioned, there's a new defense added, the whistleblower provision, which is a great new provision in this area. There's also a limitation on injunctive relief, and I call it the state law carve-out. Basically, it allows state law in the area of unfair competition, non-compete agreements to continue to apply. And finally, there's significant changes, some significant changes to the criminal provisions. One in particular is it makes trade secret misappropriation a predicate act under RICO. So just quickly, some basics for those that don't know about trade secret law. There's 3 elements. The plaintiff needs to own a trade secret. The defendant has to have misappropriated that trade secret, and compared to other areas of IP, trade secret law is, in a sense, an intentional tort. It requires knowledge or reason to know of the misappropriation. And then the third element is the plaintiff has to prove that they're entitled to remedies. Fortunately, it has a broad remedy provision which allows at least injunctive relief, but whether or not you can get damages is really a big issue. The definitions of trade secret, as I mentioned, in the DTSA and the UTSA are essentially the same, but there is a difference that's, I think, very important. I don't think that when Congress was adopting the DTSA that they quite understood the consequence of attaching a civil claim to an existing criminal claim. First of all, how criminal laws are interpreted and applied is different than how civil laws are interpreted and applied. In other words, it's more stringent scrutiny with regard to ambiguities and that kind of thing. And so, but they just tagged the civil claim onto the criminal law claim. Under the existing EEA, the definition of trade secrecy was always different, and it was kind of odd why that was so. But as long as they kept it as a criminal proceeding, nobody really cared that much. And if you look at what was handed out, you can look up the definition of trade secret. What they did was they went ahead and modified that definition, the DTSA, to conform it more to the UTSA. And the significance there was that under the UTSA, trade secrets do not apply to information that is generally known to the public, and it also doesn't apply to information that is known within a particular industry. So you can have a situation, and I always use this example, where oil drilling is not, technology or know-how is not generally known among the public, but it's certainly known among oil drillers. So that would not be a trade secret. Arguably, that wasn't the law under the EEA until the DTSA amended it. What's interesting about the EEA is it doesn't apply technically to all information. It only applies to certain information. And the history I heard about that is basically when the EEA was being adopted, the entertainment industry was afraid that their executives would be thrown in federal prison for hearing ideas from people for television shows and movies and so forth. And so they asked for the language of the definition of trade secret to be narrowed under the EEA versus the UTSA, and they got that narrowing. That narrowing was not changed with the DTSA. So the significance here is the combination of the Commerce Clause requirement and the narrow definition of trade secrets means that not all trade secrets will be subject to a DTSA claim. And that's one reason why the DTSA, the federal law, did not preempt state law. If it had preempted state law, there would have been a bunch of information for which there would be no claim. And so it was important that they didn't preempt state law. So let me turn to the social justice issues that I see in trade secret law and that I think have been there for a long time. You might know this, this photograph. This is actually the sculpture in front of the Fair Trade Commission in Washington, and I think I'm okay making a photo of it because it was actually commissioned during the Depression era, I think, as a WPA project, which means it would be owned by the copyrights would be free under Section 105 of the Copyright Act. But anyway, what it symbolizes, the horse symbolizes competition, okay? And so, and the man holding back the horse symbolizes the government trying to control competition. And so our general rule in the United States is we want the horse to run free. But we know there's some situations where the horse will trample other people. And so we kind of control the horse. And so our general rule, and this is in the restatement provisions regarding trade secrecy, is that free competition is the rule and IP is an exception. And that's true today. That particular principle is reflected in a number of provisions of the UTSA and the DTSA. First of all, trade secrets are limited, and for those who don't know, it does not apply to all secret information. It does not apply to all proprietary information. It only applies to certain, a subset of secret information. That information must be secret, have independent economic value, and be subject to reasonable efforts to maintain secrecy. So a lot of the information, in fact, that Professor Manel was talking about that's used in the whistleblower situation probably wouldn't qualify for trade secrecy anyway. But the companies, assert that in a way that was abusive towards whistleblowers, which is one reason why the whistleblower provision is important. The other thing that we have is Section 7 of the UTSA, and we have to be careful not to confuse it with Section 7 of the DTSA. Section 7 of the UTSA was explicit in displacing all tort claims for violation, misappropriation of information, or what the comments say, competitively significant information. So basically, the only claims you have under the law, except in New York and Massachusetts and North Carolina, is a breach of an express contract, breach of implied contract, and trade secret claim. If the information, it cannot be protected by those three things, it cannot be protected. And because we want information to be free. And there's also limits on the length of injunctive relief in the DTSA and UTSA. You only get to protect trade secrets while the trade secrets exist, or for what's known as the lead time advantage. Okay, social justice issue number 2, information diffusion. We have long in this society valued the collection and dissemination of information and knowledge and education. I don't know if you know what this is a picture of. This is a picture of the James J. Hill Reference Library in St. Paul, Minnesota. James J. Hill was a very famous industrialist, railroad guy. And so he donated a lot of money to build this unbelievably beautiful library because he thought, and a lot of people in the early 1900s thought, that the information of the diffusion of information was important. And so this is in our laws. In many Supreme Court cases in the IP area, Sears, Compco, Kiwani, Feist, Bonito Boats, Walmart, I can go on, represent this basic principle that we want information to be shared. And so under trade secret law, in addition to the limitations I already mentioned, the idea behind trade secret law is it actually facilitates sharing. Because if I'm willing to give my trade secret to Peggy, then I will be more willing to give it to her if I know that it can be protected, if we have a duty of confidentiality. So that's the theory, one of the theories behind trade secrecy, and one of the reasons it was held not to be preempted by federal law is because it does facilitate the sharing of information within a confidential, within a duty of confidentiality. And also, the other thing about trade secret law is it's intentionally leaky. And because it's intentionally leaky, it isn't preempted by patent law, and it also, the leakiness of it also ends up facilitating the diffusion of information. The third social justice issue that is very important is employee mobility and personal growth. Now, this particular issue has, comes up more with respect to laws that are ancillary to trade secret law. And Professor Manel mentioned it, the laws regarding non-compete agreements, non-solicitation agreements, invention assignment agreements. Generally speaking, those are restrictions on trade, and restrictions on trade are looked at, scrutinized carefully. In California, my home state, I'm very proud of the fact that we have a law dating from the 1870s which makes non-compete agreements void ab initio, except in very rare cases. And that would include, and that would arguably include, not include the protection of trade secrets. So in California, non-compete agreements are just probably not going to be enforced, except if you're purchasing a business. So that's the law that protects these interests outside of trade secrets, but is closely related to it. But the principle within trade secret is the idea that general skill and knowledge is not protected by trade secrets. So when you go to work for a company and you learn and grow at the company, and you actually learn how to do stuff. So when I went to my first job as a lawyer, and I learned how to practice law. When I went to my second job as a lawyer, I got to take my knowledge of how to practice law with me. And so that's a principle of trade secret law, and it's very clear under US law, and it's also clear under the EU Trade Secret Directive. Unfortunately, it's not specifically mentioned in the DTSA, but hopefully the courts in interpreting the DTSA will recognize that particular limitation on the scope of trade secret law. So finally, the last social justice issue I want to mention is one of government transparency. And I think there's two parts to this. One is what must and should be disclosed by trade secret owners to the government. And secondly, what must the government disclose to the public? So with respect to the first issue, there's a lot of misunderstanding about this. There was a case years ago called Reconciling versus Monsanto. And basically, the U.S. Supreme Court in that case held that there was a takings issue because of the disclosure of certain information. And so a lot of people then read that case and say, oh, well, there's this general property right, and if you take my trade secrets without just compensation, then you're violating the takings clause of the Constitution. And when you read that case, it's not what it says. What it says is the government, in adopting the regulatory scheme that was involved, had made a promise to the regulated industry that they would keep certain information secret. And because those companies had what the court called an investment-backed expectation of privacy, then that became a takings. But underlying that decision is the government can decide that if you want to work in this area or you want to do business with us, you must disclose this information. Now, there are reasons why the government might want to keep that kind of information private, but they can decide that on their own. And in fact, I understand in the in the antitrust area, when the DOJ and the FTC come knocking about your potential antitrust violation, people turn over everything. There's not even a question, oh, we're not going to turn it over because it's confidential. They turn over everything, and there's no promise of confidentiality. So to me, the issue is, basically when does the government need to promise confidentiality in order to get cooperation and that kind of thing. And so those are the types of issues we need to look at more. But there's so many issues in this area. You've been hearing about it. The validity of voting machines would be one coming up soon. And so this is an issue that we need more study on. And I think I'll end it there so that you can hear from Professor Ryan.
Sure. Thank you, Sharon. That's a really great segue into Megan's talk. She's going to be speaking a little bit more about the social issues and algorithms and transparency issues that are related to this, and she's going to be using a PowerPoint in relation to that. So, Megan.
I just had to find it.
Oh, yeah, let's set that up first.
That's fine, I don't need it right away.
Okay.
Go ahead.
Okay, Megan, Sharon spoke about the whistleblower provision of the DTSA. Are there any other major social justice issues related to trade secret law of which we should be aware as practitioners and, as owners, clients?
Sure. Yeah, I wanted to talk primarily about something closely related to what Professor Sandine labeled social justice issue number 4, this issue of transparency that really goes hand in hand with trade secrets. So when we have this lack of transparency or the secrecy involved with trade secrets, it really create some social justice issues. One area that I've become particularly interested in recently due to my work on another project is in the area of criminal justice. So I know most of you do not work in the area of criminal justice, but as you'll see, you might actually become more interested in it as criminal justice is relying on advancing science and technology, which then interfaces or intersects with IP rights. So, as Peggy mentioned, when I was in active practice, I was an IP litigator, and then when I entered into academia, I sort of set my IP expertise aside and focused more broadly on law and science issues, as well as on criminal justice issues and tort issues. But these recent advances in science and technology that we see in the world of criminal justice have really pushed me back into this world of IP law. And it's nice to be back with you people. It's been probably about a decade since I've really been thinking about IP law specifically. So as the world generally makes use of advancing science and technology, IP law is really becoming more relevant to the everyday person, people who are not in this room, everyday Americans. So in the area of criminal justice, we see police officers, we see judges, lawyers who are making use of new science and technology to improve policing, to set bail, to predict recidivism, that's repeat of criminal offenses by offenders, measure blood alcohol levels, match fingerprints to suspects of crimes, etc. So I just wanted to give you a few examples of the technology. Up on the screen here, I have PredPol, which is software which some police departments are now using so that they can concentrate their limited resources on certain geographical areas where the algorithm predicts crimes most likely to occur. You can imagine how useful this can be, especially when you have a police department that's very cash-strapped, but there are concerns with using this type of thing. Things like whether the software actually works or how well it works, whether police departments' uses of this type of software is actually effective in reducing crime rates, which is the goal of it. And there are also concerns about whether use of software like this is discriminatory in nature, because it generally means that there's going to be greater police concentration of resources in neighborhoods that are generally low-income areas and high minority areas. When science and technology is used to predict future dangerousness, and this is something that can have an impact on determinations like bail, sentencing, and parole, we have similar concerns about discrimination, and they're actually really heightened in this area. So factors that are used in these calculations include things like employment status of the particular person you're looking at, whether that defendant's parents have been incarcerated, and the concern is that oftentimes these factors tend to be proxies for race and also socioeconomic status. We also see the use of algorithms in another area, things like looking at the blood alcohol content of someone's blood, the blood alcohol levels, and also in matching fingerprints. Here, there's less of a concern of discrimination, but there's still concern about the reliability of the algorithms that are used when police officers employ this technology and then when prosecutors rely on this for convictions. So these are the types of scenarios that you might see in shows like CSI, right? But as my engineer friends are shocked to learn, which is surprising, you wouldn't expect this of an engineer, the science and technology is not actually as advanced in these areas as you see on CSI, and we don't have the same sort of reliability with these types of technologies generally that you see on TV. But all of these examples have in common the same transparency problem that trade secret law can actually pose for social justice. So let me detail this problem for you a little bit. Where science and data, or big data generally, are being used, especially in this area of criminal justice, there are some different rules at play than we see in the world of IP law. So as you know, much of IP law is based upon this constitutional compromise generally of gaining, in a lot of circumstances, exclusivity rights in exchange for sharing your work with the community. Society benefits from having access to the knowledge of your creation, and the inventor benefits from having rights which allow for, hopefully, great profits from the exclusivity. Of course, depending upon the particular IP rights that are at play, the extent of the disclosure and the extent of the exclusivity are going to vary, right? So if we're talking about patents generally, we're talking about a 20-year exclusivity right? There generally has to be full disclosure here. Well, at least in theory, there has to be full disclosure, or even if there's some question about what's the extent of the disclosure that's necessary, it should be commensurate with the protection that you actually gain as right of the patent. Trademarks can be protected so long as they're in use, and while disclosure is generally necessary, here it's usually not a problem, right? The whole point of trademark law generally is to make the general public informed about your product. Copyrights, good for 70 years after the death of the author, although the term can vary if you're talking about works made for hire. But while disclosure is not strictly required in this context to gain copyright protection, if you have it registered and therefore disclosed, you have some major advantages as compared to as if it's not disclosed. And to actively protect your copyright, you're going to need to have disclosure generally. Trade secret protection in some ways is the exact opposite, especially with respect to patent law. You don't want to have disclosure in this context. You want secrets, of course. And in fact, disclosure is going to inhibit your ability to protect your intellectual property at issue here. So the spectrum of secrecy poses a problem when we have matters involving public interest. So imagine that you are a criminal defendant. The main evidence that the prosecution is relying on for your conviction is a fingerprint found at the crime scene. The FBI ran this print through AFIS, automated fingerprint identification system, and your print was one of the handful that came up as a potential match. Now, as a little bit of a background, the use of AFIS, this automated fingerprint identification system, isn't, again, as accurate as you see in shows like CSI. Generally, there are two steps in this process. First, the fingerprint is run through AFIS, and AFIS spits out a few potential matches, right? And then you have a second step where you have a fingerprint examiner, a human, who makes a determination of whether there's actually a match. And with respect to the second step, the human component, there's been a lot of criticism in the criminal justice community, and there was a big report in 2009 by the National Academy of Sciences that's not really reliable because the human becoming involved makes this a subjective determination. So that's sort of its background. There's this concern about the second step of the process. With respect to the first step of the process, running the print through AFIS, there seems to be, at least in the criminal justice community, quite a bit of faith in AFIS. Though despite the fact that there hasn't been a lot of scrutiny about the reliability of AFIS. It hasn't been a thorough investigation about how accurate it is in creating these matches. What's the probability that the fingerprints it spits out are actually matches? Like many of the technologies I've mentioned, in the criminal justice world, this is heavily relied on because of the objectivity of the algorithm. It's computerized, and therefore generally criminal justice lawyers are going to rely upon it because they generally don't have the resources to think carefully or the background to think carefully about the reliability issue. It has the appearance, at least, of objectivity, and it has the advantage, at least according to generally the criminal justice community, that it's rooted in big data. It makes it objective rather than subjective, like the human going in and trying to match up the fingerprint. So the fingerprint match is going to be try to be used in court to get a conviction against you. As a defendant, you're going to want to challenge probably the algorithm upon which it's based, or the source code, to determine whether it's actually a match. It's central evidence to the conviction. Now, you may be trying to challenge this for a number of reasons, right? Maybe you know that it can't actually be your fingerprint because you weren't there at the scene of the crime. You've never been at the crime scene, in fact. Or maybe you just want to hold the prosecution to its burden of proof beyond a reasonable doubt. But either way, you want to challenge the technology behind this match that landed you in court, and this match that has put your liberty at risk. In fact, you have a constitutional right, generally, to put the prosecution to the test, right? To put on a defense and use your resources to try to challenge this conviction. But how are you supposed to do this if you don't have access to the algorithm, if you don't have access to the underlying source code? Now, there hasn't been a lot of publicity about this problem that criminal defendants lack access to the technical information upon which their convictions are actually based, which seems to amount to a due process violation. But it remains a problem nonetheless. And again, I think this is related to social issue number 4. Now, there's a question about whether this is a new problem. Well, this problem isn't completely new, but it's been significantly exacerbated in recent years. First, the criminal justice system, like many areas, relies more heavily on science and technology than it did in years past. Also, science and technology that's at play in this arena is increasingly complex, so it's very difficult for lawyers in the criminal justice world, for judges, et cetera, to understand the technology upon which this is based. So many judges and lawyers are often left in a situation where they're simply asked to trust the technology. And this problem of secrecy, the proprietary nature of much of the science and technology is used as shielding these algorithms from scrutiny. Even without the secret nature of this, although that's a huge problem, there wouldn't be a complete resolution of the problem because much of the relevant defense work in the criminal world is by publicly funded attorneys. And if you know anything about criminal justice, there's a real question about the resources being made available for public defense. And that's really a social issue in itself, one I'm not going to talk about today. But another reason why this problem of secrecy in the criminal justice system has become increasingly concerning is because of the Alice decision. Sorry, I'm skipping back into patent law a little bit. The Alice decision and its progeny. So after Alice, there are significant questions about getting patent rights for algorithms, right? Algorithms and software. So there are real questions, if you're a creator of this technology, as to whether you ought to pursue that approach to protect your intellectual property. And there are real limitations also to copyright law protection in this area, right? Because it's generally pretty easy to come up with a very similar but not identical source code that can achieve the same or very similar results. Now, this uncertainty of copyright protection and the certainty, even more so, of patent protection in this area means that creators of this type of technology are being pushed in the direction of keeping their technology secret. And this leads us to trade secret law, right? They're going to take special steps to try to protect this technology, first so it can get into the trade secret realm, and also just generally to protect their interests here. Now, there's been some discussion in academia about how the uncertainty of Alice and its progeny related to software and algorithms and source code has other effects, right? The effects of decreasing investment in research and development, and also the ability to build upon prior inventions, right? Not only might businesses not decide to not opt for disclosure to gain questionable patent rights here, but even if they do opt for protection, there's this problem that they might be very limited in what they claim and therefore what they actually disclose. As an example, here's a patent on something related to APHIS, right? Something in which one particular APHIS system is built or is premised. The fingerprint matching system that I was talking about before. Just by looking at the patent, though, it's difficult to determine how a match is actually being achieved go, I don't have the entire patent obviously up there, but you can go take a look at it. Even if the criminal defendant has employed an expert in the area of math, in the area of computer science, or an engineering expert, a challenge based upon what has been disclosed in the patent is going to be exceedingly difficult, especially considering, again, who the actors generally are in the criminal justice system, people who are generally not practiced in dealing with this type of science and technology. So the new struggle in the criminal justice system with the reliability of science and technologically based evidence shows, again, this additional effect of this post-Alice confusion that we have with respect to patent law, trade secret law, algorithm, software, et cetera. This prevailing uncertainty, again, negatively affects issues at which there's this public interest at stake.
Megan, I wanted to ask you, when we were talking about with Professor Manel brought up, the Will and Grace effect, kind of. Mm-hmm. Do you think shows like CSI and Law and Order kind of make the public put too much trust into these kind of algorithms and too much trust into these ideas that the fingerprint match is going to happen, it's going to be 100%?
Certainly. So if we want to get into criminal justice issues, in the criminal justice world, we actually call it the CSI effect. So the CSI effect is this idea that, well, actually there are two. There's a CSI effect and the reverse CSI effect. One concern is that jurors are going to completely trust forensic evidence and give it too much weight. The opposite side of the coin there, shows like CSI generally have the prosecution side always being right, and therefore they tend to trust police officers and prosecutors more as well. But the CSI effect itself is the concern that not only is the stuff reliable, but you have jurors actually asking for DNA evidence in every single case when DNA evidence is actually not available. So that's certainly a concern here. But with respect to the issues I'm talking about, it's really the secrecy behind this, and I think jurors are not asking a question, which isn't surprising considering the prosecutors, well, maybe understandably aren't asking the question. Defense lawyers aren't asking the question, and the defendants themselves, and judges aren't as well. So I think thinking about how the secrecy is problematic is a huge criminal justice issue that hopefully IP lawyers can help fix to some extent by realizing that there are broad social justice issues that play out in other areas of the legal system.
Yeah, if I could interject on that, because one thing to realize about trade secrets and the assertion of trade secret rights is it doesn't just come up in criminal cases or in trade secret cases. It comes up in all civil cases. Anytime you're asking for discovery of any information that the other side might think is a trade secret, you get into these difficulties, and it becomes much more expensive to litigate the case, and so it's really a problem.
Also, think about the election coming up November 8th, right? There's been a lot of publicity about whether voting machines are going to be hacked or somehow the results of the election are going to be hacked. There might also be basic questions about the algorithms upon which voting machines are based. And again, outside the criminal justice context here, you have real questions about what is that underlying technology and can we have access to it? You might imagine, though, in this context that the government might only agree to purchase the technology if you can actually have access to the underlying technology, because it's very important, right? When you're talking about the criminal justice system, again, because you generally don't have that sophistication with science and technology, and also probably not the same sort of political capital to protect criminal defendants that you do with respect to voting issues, that perhaps it's even a bigger problem, at least in my view, in criminal justice issues.
So what other issues of transparency do you see outside of the criminal justice context?
Well, again, I think the main one that's really pressing right now is the idea of voting, right? Voting technology. But as Professor Sandin was suggesting, it could happen in any possible area, right? But I think IP lawyers are really most often the people with the backgrounds necessary to understand the science and technology issues here. So I think it's really great that Professor Robinson, Professor Taylor, SMU, and everyone who had a hand in putting together this conference focused on this topic of social justice issues because there is a real need for the expertise of IP lawyers outside of the traditional narrowly focused IP law. So hopefully all of you are getting excited about the issues that are talked about today.
Yeah, and let me, on the other topic, there is a trade secret scholar who writes a lot in this area. His name's David Levine. And the other areas like fracking, what is the chemical that's being used in fracking? When they had the Gulf oil spill and they were spraying, what do they call it, some sort of chemical on top to break up the oil. They weren't disclosing what was in it, and so that it just comes up time and time again. And the conflict is, even though it might be possible to say to the, when the government purchases something, thou shalt disclose the trade secrets. Number one, that might reduce the number of companies that are competing for those government contracts and therefore raise the price. But usually governments will agree to secrecy in those situations because they want to keep it secret for certain purposes. But there are other purposes where we don't want to keep it secret. So for instance, we do want to keep how computers run the lottery secret so people can't cheat the lottery. We do want to keep out the computer systems for voting secret so people can't cheat. But there are circumstances where then that information has to be disclosed in a certain context.
Yeah, I think algorithms, as IP lawyers, we have to understand it's becoming big money for, companies. Netflix has invested billions in the algorithms just to choose, what are you watching, what should we suggest, what might you be interested in, that home screen that you pull up on Netflix. They're timing, they're counting how long you watch movies, whether you stop watching the movie after 7 seconds. And it kind of goes hand in hand with, as IP practitioners, into big data and cybersecurity and other concerns that we should be interested in for our clients in terms of transparency and social justice as well. What kind of data are we consenting to when we click I agree on those EULAs without really reading them?
Yeah, it includes, of course, credit scoring, and that's a problem if you don't know, if you have a low credit score and you don't know why. Now, the federal government has regulated that somewhat, but employment practices where companies are offering software now where you're an employee, you just plug in their information and then it decides whether you should, hire this person or not. So algorithms are being used all over the place and are generally kept secret, and it's very frightening in a lot of ways.
As practitioners, we'll be on both sides of the issue, so it'll be important, as a legal community to see which side, we kind of want to push on and which side we really want to lobby for. So, anyone have any questions that we want to take from the audience? I know we covered a lot, and the DTSA can be kind of daunting since it's so new. And most people are probably familiar with the UTSA. Any questions about algorithms or criminal justice or anything?
Actually, I have a question about confidentiality of non-disclosure agreements. It's very common in connection with civil litigation for the parties to request, usually a large corporation, to request confidentiality of certain documents that are being disclosed in discovery. And there often are sanctions set forth in the agreement if there's some disclosure of that information. And it often can be difficult for plaintiffs, especially if they're not large companies, to kind of fight that when they believe that the information actually shouldn't be kept confidential. And so I was just wondering if this new law at all has any impact on that, or if you have any ideas about arguments that could help in that situation to try to maybe alleviate that and get some disclosure of some of the information.
I'm so glad you brought that up. And before I became a law professor, I practiced law for 15 years, and one of the cases I had was we represented the California lottery, and it was a breach of contract case, And we went to do discovery, and the other side wouldn't produce because they said the information was trade secret. And we spent scores of hours and thousands, tens of thousands of dollars just to get a protective order. We went to the trial court judge, and he threw his hands up, and then he appointed a special master, and he threw his hands up, and finally we had a protective order that only allowed us to look at the software if it was in the California Lottery's facilities, in a room within the locked facilities, on a computer that only it was on, that only 2 people could access, on Sundays at 2 o'clock. It was ridiculous. But here's the thing, so there is a provision in the DTSA which follows the UTSA, which is, but it was there already, to require courts to enter protective orders. One interesting thing about the DTSA, it gives, and I think you'll find this interesting, it gives trade secret owners what I call standing to intervene in a criminal proceeding to protect their trade secrets and to ask for protective orders, which I think has really huge due process, scary implications. But here's my advice for all the attorneys in the room and litigators. When you're negotiating a protective order, particularly or any confidentiality agreement, when it's reciprocal, the tendency is just to go, oh, it's reciprocal, so they'll protect mine, I'll protect theirs. We don't have to be really precise about what's a trade secret and what isn't. And my advice is do not do that, because what happens is if you don't carefully differentiate at the beginning what's a trade secret and what isn't, the practical reality is down the road, it will be claimed that everything that was disclosed was a trade secret, and then you're in trade secret litigation when all you should be in is a breach of contract case or maybe a sanction case for disclosing, information that was protected by a protective order. So you need to have that battle up front, but as you're suggesting for the little guy, it can be a very costly battle. And so what needs to happen is courts need to be careful. They need to understand that people over-assert trade secret rights, and they need to demand proof before they allow broad protective order for trade secrets. Confidential information, that's fine, but don't label everything a trade secret, because then it sets the basis for a trade secret claim, which has greater remedies than either breach of contract or violation of protective order.
So in regards to, we've talked about the whistleblower immunity provision a lot today. What implications do you think we need to be significantly aware of for employers and employees?
Okay, so first of all, it's a great defense, and it's a new defense that applies to all civil and criminal matters. So it's state or federal. So even if you have a state case in Texas, not a federal case, no federal claim, you can still raise this defense. The thing is, it's arguably limited because it only applies to disclosure, and so trade secret misappropriation is 3 wrongs: disclosure, use, wrongful disclosure, wrongful use, wrongful acquisition. So it would only apply to wrongful disclosure. But it does have a notice requirement that was mentioned by Professor Manel. The employers have to give notice of this immunity, and it's spelled out in the statute. You can either give notice in a separate confidential non-disclosure agreement, or in the policy of the company. And if you do not give notice, then you lose your remedies, certain remedies. You lose the ability to get attorney's fees and exemplary damages, which aren't granted in all cases anyway, so it's not that big a sanction, but if you don't give the notice, you can lose those remedies. And I should mention that even though the consequences of not giving notice are not that great, in my opinion, it's still the law that you have to give notice, so I advise my students that they have to follow the law.
As you said. Megan, when we see we've seen a lot of difficulty with courts trying to grapple with understanding patents and, maybe some of the more technical things that they don't have backgrounds with. Do you think we'll see that same kind of difficulty rise in courts with algorithms? Will there be more expert witnesses? What do you think about that?
Generally speaking, or in the criminal justice arena, or?
Either.
Okay. I mean, in the criminal justice arena, I'll start with that. Recently, I think there's been a wake-up call with respect to the need to question scientific and technological evidence. So you may have seen headlines all over the place about wrongful convictions, bite mark evidence, questions about DNA evidence used in Houston, for example. There was a big scandal down there. And judges only, in the last decade or so, which is short time period in criminal justice, judges and lawyers have really become attuned to these types of issues. So I think sort of the first wake-up call is here, but as I suggested earlier, there's still heavy reliance, and right now we're moving towards greater reliance on sort of algorithms because of the allure of their objective nature. And so when people, and this is generally the case in the criminal justice community, don't have the scientific and technological backgrounds, I think they think it's certainly a step above individuals making decisions about parole, how dangerous a person is. And that may be true. It may be an improvement, and in some ways may be an improvement in reducing biases, whether those are explicit or implicit biases. But there are questions raised about whether there are biases built into the algorithms, especially when you're talking about the policing and sentencing related algorithms. So I think right now that while there's been sort of a wake-up call with respect to science and technology and the need for reliability in those areas, I think where algorithms are concerned, there's a bit more work to do in the criminal justice arena. More broadly speaking, I guess I've been thinking sort of narrowly about this, but I think it's probably the same is true. And depending upon what pocket of law you're in, that first idea of the wake-up call with respect to the reliability of science and technology maybe hasn't even happened. I think in criminal justice it has, but in other areas of law it's probably not there. I can't really think of any examples off the top of my head, but I'm sure there are many. And so I think there's, in this world of big data, it's very tempting to think that we get greater reliability as a result of looking at big data through the tools of algorithms, and thinking that the source information, right, the data upon which that is based, is reliable. But there, in lots of areas, there are huge questions about the reliability of that. In the criminal justice arena, you're basing it on reports by police departments about how many arrests there were or anything, and they have incentives to not be completely truthful in that, and they're sometimes just sort of careless in reporting that data. So I think sort of broadly, because big data is so alluring and so sexy these days, I think there's a lot of reliance on algorithms, but I hope that people with scientific and technological backgrounds can sort of push the pause button a bit and make it known that we really need to question what these algorithms are doing and what the bases for them are. And I think they certainly can be helpful as long as they're the right algorithms and the proper scrutiny is taken.
And in your research, have you come across, are there, kind of the same major players that are churning out these algorithms? Are there going to be some antitrust issues that we have to worry about all the algorithms are in the same hands, like all the companies are kind of following, it's the same company shopping it to different people?
I don't think in the areas I've been looking at, there are a number of players that I don't think we run into antitrust issues, although I must say I'm not an antitrust expert by any means. But the reasons there are still quite a number of players is because the technology is in quite early stages, actually. Like I said earlier, it's very different from what you see on CSI. It's pretty rudimentary, these types of algorithms. They're portrayed as really great, but it's very complicated to do, like fingerprint matching. It's hard. And so the technology is not completely there. And as a result, in some ways, it makes it easy for new players to get into the game. But at the same time, because of the secrecy, it's it's difficult to build on what's already been there. So you haven't seen a lot of steps towards improved algorithms or greatly improved algorithms because all the individual players are keeping all of their advancements secret. So, and it's oftentimes tough to reverse engineer these.
Right, that makes sense. Okay. Thank you very much. I think our panelists will be available after if anyone has any other questions.
Thank you very much, guys.